All right, I think we're going to get started. My name's Jared Bryant. I'm the office leader for Faegre Drinker here in Denver. And I just want to say, first off, thank you everybody for making it down on a Friday. Really appreciate it. And I also just want to say this is one of our favorite events to host of the entire year. We're really honored to be able to host again the U.S. Supreme Court review and partner with the University of Colorado Law School in doing that. So we've been doing this a number of years now. This term, obviously, no different than the last few. Lots to cover, lots to discuss, and lots of exciting content from our panelists. So I'm really excited about that. And I know my role, and I know you're not here to hear from me. So I'm going to turn this over to Professor Deep Gulasekaram, who's going to introduce our panelists. So first off, thanks everybody for coming.
Thank you, Jared, and thank you for Faegre Drinkers' support of this event. We very much appreciate it. As Jared said, my name is Deep Gulasekaram. I am the director of the Byron White Center for the Study of United States Constitutional Law at the University of Colorado Law School. We appreciate the Colorado Law School community of alumni, students, faculty, staff, friends, and members of the law school community, both here in this room, as well as around the nation in virtual participation. Thank you to my panelists. To my right, I'm going to introduce them in just a minute. We are here to talk about the 2023-2024 term of the United States Supreme Court. Just some overall statistics about that term: 62 rulings issued by the court from October to July of the last court term. Of those, the Chief Justice, Justice Thomas and Justice Sotomayor, each wrote 7 opinions. Justice Kagan, Justice Kavanaugh, and Justice Gorsuch each wrote 6. Justice Barrett and Justice Jackson each wrote 5. And Justice Alito wrote 4 of the opinions. The term, I think in general, as you will hear, featured significant rulings on judicial power, on the structure of our government, on executive authority, structural divisions between the branches of government, and some potentially important First Amendment / tech cases as well. So that's the overall view of the trends in the court for this last year. The panelists are going to get into specific cases. I'm going to introduce them all right now. They have much more lengthy bios and very impressive CVs. I will just be brief in introducing all of them, and then we'll get started with our first speaker. To my right is Aaron Van Oort, partner here at Faegre Biddle. He is the head of Faegre Drinkers Appellate Advocacy Group and a former law clerk to Justice Antonin Scalia. He's a graduate of University of Chicago Law School and the University of Minnesota. To his right is Professor Jonathan Skinner Thompson at Colorado Law. He's an expert in administrative and environmental law. He was also an attorney at the EPA prior to joining the law school. He is a graduate of Duke University, where he got his JD, and University of California, Berkeley. To his right is Shannon Stevenson, the Solicitor General for the state of Colorado. She was previously partner at the law firm of Davis, Graham, and Stubbs, and a previous law clerk to Judge David Ebell on the United States Court of Appeals for the 10th Circuit. She earned both her BA and her JD at Duke University. And finally, to my far right is Professor Douglas Spencer from the University of Colorado Law School. He is an expert in election law, and he also teaches constitutional law at the University of Colorado. He came to us from the University of Connecticut and was previously visiting professor at Yale Law School and the University of Chicago Harris School of Public Policy. Professor Spencer has a PhD in jurisprudence from the University of California, Berkeley. That's where he also earned his JD and his master's in public policy. He has a BA from Columbia University. So let's get started with the substance of our program. I'm going to turn it over to Aaron.
Well, we're going to jump right in to this low-profile case, Trump versus the United States, where the question was, in my framing anyway, does a president enjoy immunity after leaving office from criminal prosecution for conduct involving official acts during his tenure in office. And the emphasis is important on all of those because the rules are different while you're in office versus leaving office, for civil versus criminal, and for official acts versus non-official acts, right? So now you have like the 3x3 matrix to start mapping out immunity decisions. So this arose, of course, out of the January 6th incidents, and the former President Trump was indicted on 4 counts arising from that. He moved to dismiss them, saying he was immune. The district court disagreed. He appealed. The DC Circuit disagreed. He appealed. The Supreme Court took the case, and it agreed in part and disagreed in part. And so that's the setup. That's what we're going to talk about. I'm going to go a little first principles on this. And when I say first principles, I mean like really first principles. So I'm going to talk, there's a fundamental human tendency. Humans, when they get in power, tend to abuse that power. They abuse it to help their friends and hurt their enemies, or promote their friends and punish their enemies. As long as there have been humans, as far as we know, this has been true. This is true of all ages of humans. If you've ever seen 4-year-olds playing, maybe some of you have 4-year-olds, you have seen them abuse power. If you've been in cliques in middle school, perhaps you have middle schools, and maybe your child has been on the unfortunate end of bullying. You've seen this. I hope your child has not been on the giving end of bullying, but right, it's universally true. If you've been involved in youth sports, you know about the abuse of power. You know about coaches playing their kids. You know about coaches not playing the kids of people they don't like. You've seen this. Have you been part of office politics? Have you been part of law school politics? They're vicious. Internal government office politics, right? This is a universal human tendency, and perhaps it is nowhere more evident than in politics, right? The abuse of power is why our Constitution is structured the way it is. The abuse of power is what was addressed in Magna Carta and Kings. The abuse of power is not new, and it is a perpetual problem. And the problem arose in this case. And here's the interesting thing about this case and the abuse of power. It involves the abuse of power of 2 types involving presidents. And the disagreement between the majority and the minority is which type are we more concerned of and what are we going to do about it? There is a concern of abuse of power by presidents. Like, this is a real concern. This is not a fake concern. President, as Justice Sotomayor pointed out in her dissent, is the most powerful person in our country and maybe in the world. That's a lot of power just sitting there ready to be abused. And the human tendency says it will be abused and has been abused and will be abused again. So what are we going to do about that? Then there's another tendency. So there's an abuse by presidents, but then there's an abuse of power against presidents. Is there any fatter target than the other side's president? And because our governments are so large and so varied, there's almost invariably going to be people in power on the other side. And what are they going to do about it? And that's a concern, right? So the concern of abuse by a president is the concern of lawlessness. It's a concern about corruption. It's a concern about what happens when people are perceived to be above the law. Like, you know, if any of you have been on the receiving end of any official malice, however petty or not, when the official who's supposed to be protecting you is not, you know what that feels like. That's terrible. On the other hand, in a country like ours and as divided as ours, and you know, it feels more divided than usual now, but we've gone through these periods before. We don't have a civil war right now, and that's something to be thankful for. But if any of you have ever gone to the Lincoln Museum and read the editorials against Lincoln, they match everything we got on Twitter right now, and they're just as vicious and vile then as now. So this hasn't changed, but the concern there is that it can make the government ineffective, abuse of power against the president. Like, we really need our president to be effective, and is particularly relevant here, maybe in a paradoxical way. Abuse of power against a president creates strong incentives not to have peaceful transitions of power. Because if you're immune in office but not out of office, what do you think a rational human being wants to do? You'd rather stay in office. And the history we have of peaceful transition of power of more than 200 years is really miraculous. When you look at history, you look at right now, Russia's not doing so good with transition of power. China, not so much. Ukraine seems to be heading in a difficult direction. Venezuela just had an election that was won by the person who is now outside of the country because of abuse of power. Like, transition of power is a big deal in thinking about structurally. So all of this is going on in this case. And the reason I'm talking about it this way is there's not a lot of text to talk about. There isn't like a constitutional provision governing this. And so people are thinking about it. And there aren't a lot of cases on it either. So people are thinking about it. And I may have just been more candid about the balancing than they were, and theirs sounds more formal, but they're doing the same things because ultimately we're sitting here and we're trying to run a country and we're trying to figure out questions of the abuse of power. So how did they figure this out? Well, it was a 6-3 decision, and it was split, according to Republican appointees, Democrat appointees, although notice the yellow on the bottom there, Justice Amy Coney Barrett concurring in part. She's a really, really interesting, important vote here. And I'm going to point out what happened on that. But let me get to the holding, like what came out of this. So the holding is presidents are absolutely immune from criminal prosecution, even after they leave office, for things they did in their core conclusive and preclusive constitutional authority. So think of the veto power, the pardon power, the appointment power, the power to recognize foreign nations. Those are exclusively in the hands of the president. Congress has nothing to do with it. Congress can't pass laws regulating the president in any way in those, including making them criminally liable. Because think about what a prosecution is. A prosecution is carried out by the executive, but it's based on laws passed by the legislature. Fundamental question at the beginning then is, well, does the legislature, Article 1 branch, have any power to do anything to the president, Article 2, on this topic? Right, that's the threshold question. And I think, as I look at the court and count noses, probably all 9 justices agree with that at a narrow set of acts. And the United States in its briefing agreed with that too. There is not agreement on the yellow. This is where it all went to heck in terms of division. So what about the things that the president does outside core presidential and exclusive presidential powers, which is most of what the president does? What about things the president does where Congress also has authority to do something, or maybe many things? The holding is that there is presumptive immunity for all official acts, with the presumption capable of being rolled back, although the details aren't clear. It's also entirely unclear how you determine what's in core and what's close enough to core and what's not. This is where the fighting is going to come out on remand and in the future. There's also agreement on the bottom. Unofficial acts are not immune, period. Like, you do something personally, you can get put in jail for it. So that's where this shook out a little, one step further just on logic here, just to help with the sorting. Number one, you can't say it was unofficial or official based on the motives. Personal motives, like personal, wanting to get power, wanting to get influence, wanting to get money, that doesn't matter as to whether it was official or unofficial. Otherwise, you wouldn't have any bright lines. You can't say that it was unofficial because it violated the law, because that's kind of the point you're asking about in the first place. Yeah, it would have been official if you did this right, but if you do it wrong, it's unofficial. No, that doesn't make any sense. Here's the problem one. The court held that you can't use evidence of acts giving rise to immunity for collateral purposes, such as prosecution for non-immunized comment. Let me give you an example of this. Bribery. If you take a bribe, that is not an official act. But inevitably, the reason you took a bribe is because you can do something officially to help or hurt somebody. So can you not introduce evidence of the thing you did or didn't do officially to prove the bribery conviction? Majority isn't super great on explaining that one. Justice Barrett says, I agree with the dissenters on this one. And then, so that's sort of the logic going on. And then let me just do a quick takeaway on this. What does this mean for January 6th? Well, the court said there are some things that he's absolutely immune from, like meeting with people in the Justice Department about prosecuting supposed election fraud. Absolutely immune. In his core authority, meeting with his top officials, doing that. So can't do that. Presumptively immune for talking with Vice President Pence and trying to convince him to ignore the results and change them. Presumptively, but not absolutely, because, the vice president going to the Senate isn't in a core executive branch that's interacting, but it seems fairly central to, the president's duties. What else? All the interactions with state officials, private parties, general parties. The court said, district court, you figure it out. Smart money is on none of that being official. Which means that the prosecution is free to move forward on some of this. The recent news is a revised indictment that tries to shift and get as much stuff out of the official bucket and into the non-official bucket. We are seeing played out in real time what it looks like when a former president wants to become president again to enjoy immunity while he's in office. And it's not really a good look. Okay, that's it. We aren't going to have questions immediately unless panelists want to chime in, because we got to stay on track. Okay, I'm going to do a setup here for Professor Skinner Thompson, who is the real expert on this. But this is so much fun. I couldn't resist. It's the most important thing. Chevron. You guys all remember Chevron? Chevron two-step. You're like, I got to stand up. It's actually a two-step, right? So step one, you ask if the statute is unambiguous, because if it is, everybody's got to follow it, including the agencies. But step two, if it's ambiguous, then the agency's reasonable interpretation controls the courts. Remember that? Okay. So this came up and it felt partisan. And the vote seemed partisan. It was Republicans against Democrats. Republicans hated Chevron. Democrats thought we should have Chevron. Did you know that it was the opposite when it came out? Really? So this is fun. So this is Justice Breyer, for those who didn't know. He is a professor of administrative law. Chevron came out in 1984. In 1986, Justice Breyer writes an article and he says, if taken literally, the court's language suggests a greater abdication of judicial responsibility to interpret the law than seems wise from either jurisprudential or an administrative perspective. That sounds a lot like he cares about Marbury Madison, like this guy, what's his name from around here? Gorsuch. Yeah, that's the guy. My former boss, Scalia, a couple of years later, loved Chevron. I tend to think that in the long run, Chevron will endure and be given its full scope. Not so much because it represents a rule that's easier to follow and thus easier to predict, though that is true, because it more accurately reflects the reality of government, more adequately serves its needs. Man, that guy could turn a phrase. Loved Chevron. And then what happens? Strange things start to happen. You start realizing implications of Chevron. One implication is, well, what if a court has interpreted a statute first and said what it is, and then an agency interprets it and says it means something different? Do you have to defer to the agency? Decision called Brand X, Justice Thomas up there on top says yes. Even if courts got to it first, agency still is controlling if there's ambiguity. Scalia says, no, you gotta be kidding me. If courts get to it first, we said what the law is, there isn't anything left for the agency to do. And then courts start realizing if you take Chevron seriously, the agency says one thing and you defer to it, then there's a presidential election, the agency now says the other thing, you gotta defer to it the next time too. And if the administration changes again and they switch back to a third, you gotta defer again. And the law is changing without the law having changed, and suddenly it doesn't feel like law anymore. People are starting going like, what the heck? And then 2015, Justice Thomas writes this concurring opinion, and he has now discovered Marbury versus Madison. Chevron deference forces judges to abandon what they believe is the best reading of an ambiguous statute in favor of an agency's construction. This terrible Brand X case held that. Who wrote that case? Oh yeah, that was you, Justice Thomas. 10 years. It's like it was terrible. Wrests authority from the courts. And then we get to Justice Kagan, and this is talking about deference of agency interpretations of their own regs. And she keeps that in a narrow decision where the chief joins. And they say, yeah, we're going to keep deference there, but so narrow. Said it has to be genuinely ambiguous, meaning like not easy unambiguous, but we apply all the tools, and just because it's hard doesn't mean it's ambiguous. And then if there's ambiguity, that still doesn't answer it, because the agency interpretation has to fall within the scope of the agent and ambiguity. So if there's ambiguity here, but the interpretation is here, no deference. And even if there's ambiguity and the interpretation is here, that's still not enough. The agency has to have done it formally. And the resolution has to implicate their substantive expertise. And they have to have done it in such a way that justifies deferring. How much deference is left at that point? My practical conclusion was none if a judge didn't want any, but there it was. And that's where we were. And then all of this is a prelude to Loper, Bright, and I hand the mic.
Before we turn it over to Jonathan, just so everyone knows, at the end, we'll have time for questions. So please do hold them, and then we'll get to them when everyone's done. And as I turn it over to Jonathan, I hope you also have prepared an interpretive dance too.
I did,
Thank you.
actually.
Excellent.
But
I let off strong, so we'll see.
it's impossible to follow, but I will try. So thanks for actually ending with Kaiser, because I think that's where it's an interesting place to start when we get to Loper. So with the Loper case being argued before the Supreme Court, a lot of commenters and court watchers thought what we were going to get with Loper was not an overruling of Chevron, but a Kaiserification of Chevron. In other words, what we were going to see was that the court was going to set up a number of hoops that agencies would have to jump through before ultimately they would receive any deference. And so really narrowing the opportunities for agencies to claim Chevron deference. And those thought, well, maybe the court's going to do something similar here with Chevron in the Loper case. That's not what happened. Justice Roberts, writing the opinion for the court, is pretty unequivocal. Chevron's overruled. It's gone. We no longer have it for many of the reasons that were discussed before as to what the policy reasons for upholding or not maintaining the Chevron rule. In any case, it's gone now. Courts must interpret statutory text. And I'll go over here. What's interesting, though, with what Justice Roberts does in his opinion, in his majority opinion, is while he gestures to Marbury versus Madison, that courts are responsible for saying what the law is, he doesn't actually rely on separation of powers to overrule Chevron. Instead, he turns to a pretty granular exploration of the Administrative Procedure Act and some of the provisions in there, specifically in APA section 706, that says courts shall decide questions of law and interpret statutory provisions. And so from this, we glean perhaps that Well, if Congress doesn't like this ruling, they could amend the APA and just say that courts should be deferring to or must defer to agencies in cases of statutory ambiguity. But there's so much in the majority opinion that gestures to and grounds the reasoning in separation of powers for all of the concerns that were articulated previously. And we even have a concurrence from Justice Gorsuch and maybe Thomas too, I forget, but that Chevron needs to be overruled because of separation of powers. So even if we see, for example, a statutory change by Congress, it's not hard to envision the court picking that case back up and saying, you know what, Congress, you can't actually codify Chevron deference. So the big question then is what's left? What do we do? How do agencies, how do advocates, how do courts handle statutory interpretation when it involves agencies going forward? And what's notable about this case is that Justice Roberts says that there is room for agencies to exercise discretion. Congress can delegate discretionary authority to agencies to implement, to interpret, to enact policy. And that's not off the table. Instead, what courts need to do is just determine what the best reading of a statute is when they're faced with some ambiguity. Exercise all of the tools of statutory construction that we know as lawyers. Look at plain meaning, look at purpose, all of that. Of course, what exactly is best? There are policy implications embedded in that decision, so we'll see how courts grapple with that. Another thing that the court leaves on the table is that now with Chevron gone, let's return to the old days of Skidmore deference, the idea that you should consider an agency's construction of the statute, see whether that is informative, and maybe not defer to them, but use that or adopt it as your own reading of the statute. And just 2 days ago, the Fifth Circuit actually interprets a regulation under the Fair Labor Standards Act. And it addresses not only the Loper decision and Skidmore deference, but also this idea of the major questions doctrine, which is from a couple terms ago from West Virginia, the EPA. And what the Fifth Circuit does is really interesting. It tries to and does provide a best reading of the statute, looks at some of the statutory terms and upholds ultimately the government's interpretation as longstanding, as the best reading of the statute. It rejects a major questions challenge, finding that the economic impacts aren't very significant. And then it says that Skidmore deference, even though the Supreme Court in Loper says it's still around, the Fifth Circuit says, we don't know that it does any work for us anymore. We're not sure what we should be doing with Skidmore. We don't know why we should even be looking at what the agency has done to inform us in this way, because if the agency's reading is not the best, which we're charged with determining at this point, we don't need Skidmore. And to the extent that it is the best, then it's not really relying on the agency's interpretation anymore. So I think what we're going to have to see now is how courts deal with this notion of what is the best reading of a statute. There's a lot of uncertainty, I think, going forward. What's not ambiguous is that Chevron's gone. So there's no more two-step, unfortunately. I don't have a dance for what the new dance Loper test
It's
should
so
be,
nice not to have the two-step.
but I'm sure we can come up with one. I'm going to turn next to Corner Post, which is another administrative law case that came out from this term. And ordinarily, if an agency adopts a rulemaking, parties, the impacted and regulated industry is likely to have been involved in that rulemaking process. They'll likely challenge the rulemaking at the end of the day, often immediately when it's published in the Federal Register. Groups can also raise as applied challenges. So let's say an agency, long after a rule has been finalized, comes after you in an enforcement action. You as a defendant potentially can also raise some challenges to that rulemaking in that enforcement context. What's interesting here is that when the Federal Reserve Board issued a regulation in 2011, that rule, I forget whether it was challenged or not, but ultimately it's upheld. And then a new entity emerges in 2018, Corner Post, a North Dakota convenience store. And they now want to challenge this rulemaking. They're not actually regulated by the rule, but they're impacted by it. What was the rule? It established maximum card payment fees for retailers accepting card payments. So every time you swipe the credit card, some percentage of that goes back to the bank or the issuing credit card. And this convenience store doesn't like this rule, but they're not actually directly regulated by it. They're never going to face an enforcement action. And so under the ordinary rules, they have run out of time to challenge it. There's a generally applicable statute of limitations provision in 28 USC 2401 that says you have 6 years to challenge a final action generally and sue the government. And they were outside of that. They still wanted to be able to challenge that because they didn't want to pay the fees, or at least the amount that was subject in these regulations. So the court is now grappling with this question: is when does a party actually become affected by a decision? In the APA, again, in the Administrative Procedure Act, litigants are required to file an action after the federal government has issued something that is final, meaning it's done. And there has to be some harm to the individual. And Justice Barrett, writing now for the court, says that the general statute of limitations provision in 2401 requires filing within 6 years after the right of action first accrues. And she reads the Administrative Procedure Act to say that the right of action accrues when the plaintiff, the person who wants to challenge the regulation, is actually injured, even if they weren't in existence when the rule was finalized. That's when it accrues. This is not tied to when the action is finalized. And so it takes a very plaintiff-friendly perspective rather than government-friendly perspective that we've seen in a number of other statutes. This is just the general rule. When another statute, another law doesn't provide a different path.
Yeah, can I take like 2 minutes and pull this together? This together with Loper is good news for people who want to challenge regulations. Okay, just the bottom. This is good news, and it's good news in a way that you may not have understood. Okay.
And in many ways, though, it's also quite limited because a number of other statutes have their own judicial review provisions. This is very common in the environmental world, which ties your right to challenge an action to the finality of the government's decision, the government's rulemaking. So this is just the presumptive rule that applies when another statute doesn't speak more specifically to the issue. Okay. And what's interesting, again, here is that Congress actually put out a bill, I think this week, in the Senate, that seeks to overturn Corner Post. Again, this is another example where Congress could react to a Supreme Court decision by just amending the Administrative Procedure Act. And what they do is to, rather than make it a plaintiff-oriented statute of limitations, they would tie it to the finality of the government's decision. They provide a 6-year statute of limitations, which is much longer than what most other subject matter specific statutes provide. In those instances, the statutory review period is sometimes only 30 days or between 30 and 120 days. So that could be a pretty simple fix for Congress should they actually enact it. But again, if you pair it with Loper, even though Justice Roberts had said that all of those decisions that were decided under Chevron Step 2, those are still subject to stare decisis or statutory stare decisis. It seems that, as the dissent points out, pairing this with Corner Post, it's very conceivable to imagine folks challenging old interpretations as not being the best anymore.
Exactly. So if any of you are in-house at a client or represent a client and want to challenge a regulation, here's a simple rubric. Step 1, are there any regulations that create pain points for your client? If yes, proceed. 2, is there any gap between the regulation and the statute? Right? Anything that may not make it the best interpretation? If yes, proceed. Are you within the 6-year limitations period? If you aren't, can you find a trade group or a new business that you could set up to bring the suit? If so, proceed. Are you in a circuit that has already addressed this under Chevron? If so, it's stare decisis. If you are, tough luck there, but can you find a plaintiff in a different circuit? Because they aren't bound by stare decisis. They're not going to apply Chevron. If there's a circuit split, it's going to go up to the Supreme Court. They aren't going to apply Chevron. And then, so, I mean, you can go through here and like we have clients in a wide variety of industries who are going through variations on this analysis right now to see what new things are open, because as Jonathan has pointed out, I at least used to think that your time for challenging regs on their face was limited to 6 years or whatever the specific statute was. And once the 6 years ran, everybody's out of luck. You aren't out of luck anymore. If you can find new entrants into that industry or newly affected parties who can challenge it.
The other option.
On behalf of government lawyers, thanks a lot, Aaron.
And I'll complicate it a little bit more.
Sorry to be so clear about that, Shannon.
The filing, what's unclear here is if a party submits a petition for reconsideration of a rule and the government denies that, and let's say the petition for reconsideration suggests that the old rule doesn't offer the best interpretation, even if it was upheld by a circuit court as lawful under Chevron, does that present a new set of facts that would allow a litigant to then attack the old interpretation anyway, without being subject to statutory stare decisis? So there's a lot of uncertainty. And I note that even with the Loper decision, I had seen that some environmental groups actually weren't too disappointed in Loper, because at the end of the day, if any party can get before a judge that would agree with their interpretation, that the statute says what it says, the best reading is, whether it's an industry group or an environmental group or whomever, is the best reading. The government, the federal government, loses out. They don't get the deference that they were able to rely on. So if it's a Republican administration, a Democratic administration, it doesn't matter. This is a more plaintiff petitioner friendly rule. And so you could be opposed to Chevron, as was pointed out. An environmental group was the first one that lost the Chevron case. So it doesn't necessarily align with your maybe political or policy preferences to the extent that you're suing the government or in the business of suing the government. The last case I want to talk about, I know I have very short time here, is the Jarkessi case, which is another administrative law case, but this time it's grounded in the Constitution rather than the Administrative Procedure Act. And here, also coming from the Fifth Circuit, we have a narrow question that's being put before the Supreme Court, which is whether individuals have a right to a jury trial under the Seventh Amendment for securities fraud claims before the SEC. So the SEC had alleged securities violations, securities fraud violations. They sought to pursue these enforcement proceedings in-house before an administrative law judge. The Fifth Circuit says that's unconstitutional for a number of reasons. But the key issue that's up on review in the Supreme Court is whether the Seventh Circuit or the Seventh Amendment would guarantee a right to a jury trial. And the court comes out and says that, yes, when a statutory cause of action is essentially grounded in the common law, when it is tied to something that private parties ordinarily could have sued each other for in the federal courts, that suggests that the right to a jury trial attaches. And Justice Roberts here, writing again for the majority, identifies two key questions, two inquiries that will help those identify whether or not this jury trial right attaches. And the first is whether the claim is similar to or grounded in the common law, something that we might traditionally see in the common law, like fraud. And two, what's the remedy at issue? And ultimately, he says the remedy is dispositive in this case. The remedy was a civil penalty. And so there's a little bit of uncertainty here as to whether that could override all other considerations, because often we have a number of statutes that authorize the government to seek civil penalties, to punish, to penalize, to deter. And so if the government's going to seek money, not just to recoup losses, but to deter future activity, those might trigger a jury right. Now, there are, again, many unanswered questions here in terms of how do you reconcile some of the other Supreme Court precedents that were at issue that I don't want to get into. But at the end of the day, I think what's notable is if you are in an enforcement proceeding with the government, you have a right to a jury trial, but do you want to be exercising that right in all times? That's a calculation to be made, I think, at the end of the day. It's more costly, it's potentially more uncertain, but at least the right exists. It changes the bargaining positions a little bit for both the government and for those who are on the side of enforcement. One thing that the court doesn't say is that Congress can never allow agencies to pursue enforcement proceedings in an administrative proceeding. They could have gone that way and said it was a constitutional justification, but they don't, and instead just rely on this jury right. That's it for me, and I will turn it over.
Jonathan and I did not coordinate an elegant transition.
No.
So I'm going to talk about 3 cases, maybe 3, we'll see if we get there, from the court this term that deal with the balance of power, the relationship between government and social media platforms, and the relative First Amendment interests that are implicated in those relationships. In the interest of full disclosure, I am not an expert on the First Amendment. I don't really even like First Amendment jurisprudence. I find it very confusing. There are people who are out there who dedicate their whole lives to it and are experts. But I chose these cases because one of the most significant cases that our Attorney General's office has going right now is a consumer protection case that we filed into an MDL in the Northern District of California, where Colorado is one of the lead states leading a 35-state complaint against Meta for harms to youth from social media. Meta has moved to dismiss our complaint, and the district court judge has told us that we might have a ruling by the end of this month, so I'm getting ready. All right, so the 3 cases I want to talk about are the net choice cases. Those cases talk about or presented the question how states can regulate content moderation by social media platforms. Then there was the Murphy versus Missouri case, which looks into the question of how can government officials ask, request, demand that social media companies moderate certain content. And the third one is Lenke v. Freed, that asks when a government official can block a citizen from that official's Facebook or other social media page. The punchline on these is that, well, there was a lot of time and effort spent and a lot of thorny issues raised on these cases. We didn't get a whole lot of answers. And so I think going forward, we can just look for these controversies to continue and further develop. All right, so we'll start with the net choice cases. These were 2 cases brought by this entity Net Choice, which is a trade association whose membership is not exactly clear, but includes at a minimum Facebook and YouTube as relevant here. So Net Choice challenged laws that had been passed by both Florida and Texas that basically said you can't use social media platforms, especially you big social media platforms, can't go in and moderate content based on viewpoint. And if you're going to moderate content in any way, whether it's deboosting it, I'll call it, banning it, banning a user, all of those types of things, flagging it with warnings, you have to send a written explanation to the user as to why you did what you did. So Net Choice claimed on behalf of the social media companies, particularly Facebook and YouTube, that its content moderation is its speech. And for example, what you get in your Facebook newsfeed is in part, at least, Facebook's speech. And certainly to the extent that it is deciding to remove content from its platform, that is also its important speech. And so these laws that were attempting to prohibit it from doing that were violating the First Amendment rights of the social media platforms. Net Choice won its request for a preliminary injunction in Florida, and that was affirmed by the 11th Circuit. It lost, or won the PI in Texas and then was reversed by the Fifth Circuit. And so those two cases went up to the court together. Okay, now let me give you a few facts from the Murphy versus Missouri case. So this case involved two states, Missouri and Louisiana, along with a handful of individual social media users who sued the US Surgeon General, the CDC, the FBI, and a whole bunch of other executive branch folks. And they said, hey, our posts, as social media users, we had our content moderated. And it happened because you, the government, told the social media platforms to do it. And that violates our First Amendment rights. And so they brought that challenge up to the court to find out whether the government officials were allowed to do that or not. The Fifth Circuit ruled on this case and basically allowed a sweeping preliminary injunction to go into place, basically telling everybody in the government, like, you cannot speak to a social media company, which was obviously quite broad. Okay, so what kinds of questions, oh, that's my pictures of the content at issue in the Murphy case was largely about, as you might imagine, COVID, vaccines, election, super non-controversial issues that the government might have had an interest in. Okay, so these cases generated a whole lot of meaty, thorny questions about the relative relationships and First Amendment rights of social media users, of social media platforms, and of the government itself. And we got to hear a lot of different opinions from the justices at these oral arguments. So one of these questions is, are these content moderation practices that social media companies engage in, are these even speech that is protected by the First Amendment? Net Choice, of course, argued vociferously yes, insisting that how social media platforms choose to curate their content reflects their editorial discretion. And the court has long recognized that curators of content, of even other people's content like that, have their own First Amendment interest in how they're presenting that. And of course, they certainly focused on their First Amendment right to remove particularly heinous content, whether it's pro-suicide content, hate speech, terrorism, all those kinds of things. And the states, on the other hand, argued, no, it's not speech. And they try to liken the social media companies to really more like common carriers or like a telegraph company. And they say, you're just the infrastructure by which other people are communicating. You and even to the extent you're using these content moderation things, they're not really expressing any viewpoint on your part that deserves any kind of First Amendment protection. So that was one question. And this kind of leads into another question that the justices expressed interest in, which is, if a social media platform is engaged in its own speech, does it then lose the protections of Section 230 of the Communications Decency Act? So that, of course, was an act passed at the dawn of the internet, designed to facilitate the growth of the internet, that basically said, if you're operating a sort of a social media platform, at the time it was more like chat rooms, you are not going to be liable for the speech that users post there, because that's just unwieldy and no one could run a chat room if they were going to be liable for everything every jerk said in there, right? And then it also said, not only are you not going to be liable for their speech, but to the extent you're trying to take down bad stuff, that's not going to open you up to liability either. And so Justice Gorsuch in particular was very interested in what is sort of a superficial tension here, which is to say, okay, social media platforms, you're saying this is your speech, right? And therefore you have a First Amendment right in it. Well, if it's your speech, then it's not protected by Section 230, right? You don't get that. And social media companies said, oh, no, we get to have our cake and eat it too. Section 230 really gives us this unique position where both we're protected for our speech and we're protected for not being liable for our user speech. And that's the way the entire statute was designed to work. That's not a question that's been resolved. And so I'm sure we're going to hear more about that. Another question that the justices wrestled with a lot at oral argument was, if a social media platform demotes or removes a user's content, is that censorship, which we normally think of censorship as something that the government is doing to you? And the states kind of pushed two theories on this. One is that if you're excluding somebody from a social media platform, you're basically banning somebody from the public square. And, like in the, common carrier situation, like this is where people have to go to express their points of view now. And so it's really not right to exclude them from it. And it's violating their First Amendment rights. And the response to that, of course, is, well, there's no, because common carriers, you usually have one option, right? You got one telephone company providing service to your house and that's it. Whereas anybody can go start a new social media platform at any time and express all the views they want on any platform that will let them. And then the second theory that that the states kind of relied on to say, no, this is censorship, is this sort of notion that the government is, as we see in the allegations in Murthy, the government is using these platforms to really control and advance its own interests. And the social media platforms are becoming sort of like state actors in that regard. So then that kind of leads us to one of the last big questions that I'll highlight. And, it comes to this tension of like, what rights does the government have to its own speech, including speech about social media platforms? And when does that speech become too forceful or coercive to the point that it's going to be liable for what the social media platforms are doing, and that convert them into state actors, basically? In the Murthy case, the government really wanted to stand up for its rights to be able to call up Mark Zuckerberg and say, hey, we can see this really troubling, wrong information going around on your website. Can you look into that, right? That's a legitimate thing to do. And Justice Jackson was particularly worried, thinking about the kinds of like public health challenges that can be caused. She was talking about, you probably heard of this Tide Pod challenge that went around on TikTok, where children are being encouraged to eat Tide Pods, which can obviously be very bad for you. And she was clearly very troubled by the notion that the government couldn't act to try to stymie that. And the states the opposing parties were very resistant to that. They wanted to be able to say, no, any interference by the government in what a social media company might be doing is just too much. And particularly here, their reasoning, I think, gets to this. It's sort of like, even if the government just calls up Facebook or TikTok, whoever, and says, hey, can you just take a look at this? There's this implicit threat happening. And the threat is, we're going to take away your Section 230 immunities, right? And because that's sort of looming over social media in a way that's different from relationships that the government might have with other media outlets, that threat is just too much to allow for the government to really be able to say anything to social media companies about what users' content should be demoted or banned. I will say it was sort of an interesting breadth of opinions from the justices. I think about this practice, which they call jawboning, I guess, where people from the government call up media and yell at them. Justices Kavanaugh and Kagan seem to indicate that I think in their practices as government lawyers had maybe engaged in some of these communications, maybe in sort of an aggressive way. On the flip side, it seemed to me that Justice Alito found it to be Orwellian that anybody from the government would ever call a social media company and talk to them about anything. So big range of opinions there. All right. So how did the court answer all of these challenging questions? I picked a CU play. That's right. They punted for the large part. They mostly did not. In the net choice case, the resolution was that the lower courts, all of them, had just completely failed to engage with the correct analysis for facial challenges under the First Amendment. And those are, and if you're going to do that kind of analysis, what you have to do is look at what is the constitutional sweep of this law? What is the unconstitutional sweep of this law? We make a fraction, and if the fraction is out of whack, then we decide that it's facially invalid. That didn't happen here. And the fact of the matter is these laws are broad, particularly Florida's was really broad. It extended to a huge range of potential websites, apps, whatever you want to call them, from like Uber to Etsy to Facebook to Reddit. And it swept in a huge amount of functions of those platforms, because we have questions about like, okay, well, what is Gmail included? Is direct messaging included? If I'm posting comments about my Uber driver, is that included? And the courts hadn't engaged with any of that. They had really focused on the narrow facts of YouTube, Facebook, and Facebook's newsfeed and YouTube's homepage. And so all 9 justices agreed that was not the right thing to do. And so they reversed on those grounds. But Justice Kagan went on for 6 of the justices to say, but let me also tell you, Fifth Circuit, why you got your First Amendment analysis completely wrong while we're here. And she delved into these arguments about, is content moderation speech? And she says, yes, absolutely. Content moderation is speech. We apply these core principles that we've had all along. And, even to the extent you're saying, it's a small amount of speech that we're excluding, that's okay too. That doesn't mean that you lose your First Amendment interest. And she also said, and by the way, whatever interest the government has in sort of ensuring a correct mix of opinions out there in the speech marketplace, that is not sufficient to violate First Amendment rights of these platforms. So she really previewed, I think, where at least 6 of the justices are going on the actual merits resolution of this. Justice Alito, for himself and Thomas and Gorsuch, wrote a concurrence, which was really just a dissent to everything that Justice Kagan said on the merits. And they basically disagreed with her on every single point, including, whether it was speech that should be regulated like that, what the government's interest was, and whether that was legitimate, and whether the platforms were more analogous to common carriers. So interesting what to do if you're the Fifth Circuit. I don't think you can really say what Justice Kagan has done is dicta, but you've been given sort of another roadmap here and way to resolve these issues. All right, let's see. I'll call this one out too. Of note, Justice Thomas also concurred to say facial challenges aren't a thing at all. I think it usually takes about 20 years for his dissents or concurrences to just become the majority opinion. So get your facial challenges in now, I guess. Okay, Murthy v. Missouri. So Justice Barrett wrote this opinion, 6-3 decision, and the outcome here, again, not reaching the merits. And unlike Justice Kagan, she really adhered to her ruling and did not get into the merits, but decided the case on standing. And she went through this really painfully exacting analysis of, wait, who are the users who said their content was taken down? What particular posts were those? When did that happen? What particular government actor told a social media platform to take that particular post down? And when you put all of those, try to line all of those facts up, the plaintiffs just weren't able to make out those connections to establish causation and redressability. There were sort of some big picture problems going on, which is many of the platforms had started moderating content on vaccines and things like that long before the federal government was telling them to do anything or asking them to do anything. A lot of the timelines just didn't match up at all. Maybe 6 months earlier, somebody from the federal government had said something about vaccines, and then 6 months later, the social media platform takes the thing down, so that the timeline for causation was not great. And then, of course, by the time this case came around, the federal government's not in the business of really doing anything about vaccines or COVID anymore. And so in terms of redressability going forward, there's problems there too. And then again, when we get the same sort of dissenting group here, Justice Alito, again, writing for himself and Thomas and Gorsuch, and again, delivering that view of, no, this is totally Orwellian. You can see there, for months, high-ranking government officials placed unrelenting pressure on Facebook to suppress Americans' free speech because the court unjustifiably refuses to address this serious threat to the First Amendment. I dissent. So clearly a very different view about what the proper role of government is in talking to social media companies on these issues. Okay. All right. I am just going to say one word about Linkey v. Freed. This was a unanimous decision. It was about setting the standard for when a government official can block somebody on his or her social media page. This comes down to whether the official had actual authority to speak on behalf of the state on a particular matter, and whether they purported to exercise that authority in the relevant posts. There's a very well-developed factual record in this case. but the court did not say whether these facts actually met that test or not. They said, we'll send it back to the Sixth Circuit. I know I've read the facts from the case. I've read the new test. I have no idea how that will come out on remand. So this really too just leaves a lot of continued area for debate and dispute. If you represent a government official, I would encourage them to have 2 separate pages. All right. So at the end of the day, you know, these issues are just coming. They're going to be coming again. They're going to be coming in more nuanced fashions. You know, from a government perspective, the demands for regulation on social media, I think both at the state and federal levels are enormous. And, you know, we're seeing these proposals come forward all the time. You know, the number of lawsuits out there against the social media companies, particularly with respect to harms to youth, are abundant. Some of you may have seen just in the last few weeks, the Third Circuit reversed a decision that had dismissed a claim by the parents of an 11-year-old who had died doing one of these blackout challenges and said, no, that case can go forward against TikTok because without her, the child requesting it, it had sort of affirmatively put that content in front of her. No grants of cert yet for the next term on these particular issues. The closest we've got is the Texas case. So Texas has tried to say that you have to demonstrate your age with an ID to access porn websites. And that law has been challenged as, you know, to keep children off of it, obviously. And that law has been challenged as burdening the First Amendment rights of adults who would like to access those same websites. So on that spicy note, I'll turn it over to Doug.
Excellent. All right, last but luckily least. So we'll do this quickly so we have time for questions.
That's my line, Doug.
Oh,
Don't
yeah,
take my
sorry.
line.
I hate that we started with Donald Trump. We're going to end with Donald Trump. It doesn't distract from the cases that actually probably impact our daily lives in much greater degree than these cases. I want to talk briefly about this home case that came out of Colorado, Trump v. Anderson. Obviously, this is Jenna Griswold, not Anderson. The original complaint was filed by petitioner Anderson against Jenna Griswold, asking her to not print Donald Trump's name on the primary ballot in Colorado. And then by the time it went to the United States Supreme Court, Trump was demanding that his name be placed on the ballot. This is a case that actually represents litigation and claims that were made in 37 states. We were not alone in wondering whether or not Donald Trump deserved to be on the ballot, despite his involvement or relationship to the January 6th insurrection. And so you can see there was litigation, there were administrative hearings, there were different outcomes across the country. The question really came down to, did Donald Trump engage in an insurrection or aid enemies of the United States? On the left, here's an insurrection, 1792, the Tuileries Palace in French that got rid of the French monarchy. And on the right is the insurrection of January 6th. And are these things similar enough? And was Donald Trump participating in a way that would violate the Constitution and violate his right to run for office? All of this comes from constitutional language in the United States Constitution, the 14th Amendment, which we're very familiar with for other provisions. Section 1, the Equal Protection Clause, for example. Section 2 overturns the 3/5 clause of Article 1 of the Constitution. Section 3 is a provision that not very many people were familiar with before 2020 or 2021. And I just want to look at the language. It had never been litigated, which meant that applying this language required a lot of interpretation of every single word that was in this particular section. So quickly, just to highlight some of the top takeaway questions that came out of this case. 1, Section 3 only applies to people who hold an office under the United States. Does the president hold an office under the United States? Maybe your gut intuition is like, yeah, of course. But the president, it says under the United States, maybe that suggests that it's an inferior officer and not the United States primary official. Okay, so we probably need to figure that out at some point. Number 2, the person who's eligible to be disqualified under Section 3 has to have previously taken an oath as an officer of the United States to support the Constitution of the United States. A question, is the president an officer of the United States? Not under the United States, but of the United States? Maybe, but if you look at other clauses in the Constitution, like the impeachment clause, it says the president, the vice president, and other officers shall be impeached. So maybe that means officers refers to somebody else. We should get a handle on that. The president, this may be a little more silly, but the president doesn't take an oath to support the Constitution of the United States. The president takes an oath to protect, preserve, and defend the Constitution of the United States, but the word support's not in there. So if you want to get real textualist, maybe there's something in there for you. We've got to interpret that. The most important question is, did Donald J. Trump engage in insurrection? We've got to define what an insurrection is. How does one engage in an insurrection? If you incite an insurrection in a speech, is your speech protected by the First Amendment? Another question that had not been litigated prior to these cases. Finally, it says no person shall hold any office. Okay, is it unconstitutional to run for office even if you can't hold that office, particularly in a primary election? Isn't it okay if a party wants to stick an insurrectionist on as their standard bearer? Shouldn't they be allowed to do that? Or are we going to say at the beginning of the process, if you're unqualified, you can't even have your name on the ballot? So all of these questions are floating around in the air. 37 states are trying to grapple with this in their own way with administrative hearings and lawsuits. And we end up with a case that came through the court system. Now, it didn't come through the court system because Norma Anderson decided to file a lawsuit and enforce the 14th Amendment. But the state law in Colorado dictates that if you want to challenge somebody's qualifications to run for office, maybe you have evidence that they're not a natural born citizen. Maybe you have evidence they're 31 years old. Different states have different mechanisms. Some states, like in Maine, the Secretary of State's office decides that. Some states, like Illinois, a state election board decides that. Our state law, Colorado Revised Statutes 1-1-13, says if you have a complaint, you take it to a state court. The state judge then hears that complaint within 5 days, and then they decide it, and they give the answer to the Secretary of State within 48 hours. And the way that it's structured suggests that maybe that's not a process that was set up to decide such weighty constitutional matters. It happens very quickly. But this is the process that we had and that unfolded in Colorado. So in a state court, there was a 5-day, I'm calling it a trial, it might be called a hearing. There was an opportunity for both parties to submit evidence. Amicus briefs were filed, experts testified, there was cross-examination. It wasn't the full federal rules of evidence kind of trial, but it had a lot of the trappings that we might think of somebody who's due process to make a determination. The district court decided that Donald Trump indeed did engage in an insurrection, and that his speech at the ellipse was a speech, but was not protected under the First Amendment because it had incited an insurrection. But, Judge Wallace said, the president is not an officer of the United States. One of those questions that I had raised before. This case was appealed by both parties. Trump didn't like that a judge had said you're an insurrectionist, and Norma Anderson didn't like that Trump's name was still going to go on the ballot, so they both appealed to the Colorado Supreme Court. The Colorado Supreme Court heard a case and wrote a 200-page opinion in a matter of days, essentially. It was pretty remarkable. The Colorado Supreme Court affirms the factual findings of the lower court. They said we're not a fact-finding body. We don't see clear error here. We affirm the First Amendment conclusion of the lower court, but we reverse the lower court because we think as a matter of law, the president is an officer of the United States, and therefore Trump's name should not be printed on the ballot. And then the Supreme Court stayed its own opinion and said, we're not going to actually require Jenna Griswold to do anything until the Supreme Court gets involved, because this is an issue that's weighty and has federal implications. And this is a move that I think was not the correct move by the Supreme Court, and I'll explain why in a few slides. But ultimately, this case goes to the Supreme Court, and the question, I need to mention this. There was a dissent in the Colorado State Supreme Court by 3 of the justices. And they said, one, this idea of using a trial or a hearing with a state judge as it's codified in 1-1-13, that's not the proper venue for doing something like this. So we need to come up with a different state law if we're going to do these kinds of hearings. We're concerned about due process. We don't think Trump had due process, essentially, to cross-examine at the extent that he deserved to maybe be barred from running for office for the rest of his life. When the case made it to the US Supreme Court, the question presented was not very particular. They did not ask if the president is an officer of the United States. They did not ask for a review whether Donald Trump engaged in insurrection. The question presented was, did Colorado get it right, or did they get it wrong? Technically, it was asking if we got it wrong, and the US Supreme Court said yes. And how did they say that? Well, unanimously, their holding is that allowing Colorado to disqualify Trump would create a chaotic state-by-state patchwork and sever the direct link that the framers found so critical between the national government and the people of the United States. This is the holding. It was unanimous. Now, there were additional opinions. There was an opinion by 5 of the more conservative justices. No, just as in the Trump v. United States case that Aaron talked about, Barrett singles herself out, and I'll talk about what she said in a minute. These 5 justices said, it's not just that there will be a patchwork, but if we're going to enforce the third section of the 14th Amendment, Congress has to do it. The federal government must do it, and it must come from Congress and not the states themselves. The 3 liberal justices balked at this idea. And they said, okay, we all agree that Colorado shouldn't be able to do this. That is independent grounds enough to end this case. Why are you now going forward and saying the only way now to do this, this wasn't presented, no one asked us what's the only way to do this, is for Congress to pass a law, and not any kind of law, but a particular kind of law, one passed subject to Section 5 of the 14th Amendment. So if you want to prosecute Donald Trump under Title 18 of the US Code, there's a federal law that was passed by Congress and signed by the president that criminalizes engaging in insurrection and bans you from running for office for life. That's okay. What happens if Donald Trump gets elected and Congress is meeting on January 6, 2025, and they say, we don't think that Donald Trump's qualified, and the Constitution says he's not because he engaged in insurrection? Can they then disqualify Donald Trump? It is Congress, by the way. No, because they didn't enact a statute pursuant to Section 5 of the 14th Amendment. What if somebody who was at the Capitol on January 6th becomes a judge, and then you get prosecuted for a crime in front of that judge, and you think this person shouldn't be a judge? They engaged in insurrection. Can you use that as a defense against your prosecution? Absolutely not, because Congress didn't pass a law. This is the dissent's concerns. What about if Colorado decides to amend its state law to cure the due process defects? Could we do that? The Supreme Court said no. Congress is the only body that can animate Section 3 of the 14th Amendment. Now, Justice Barrett sees this fighting going on, and she says, everybody needs to simmer down, right? We all agree that Colorado can't do this. We all agree states should stay out of this business. All of us agree that's the message that everybody should take home. Okay, one small note. It's not a small side note, and that is that the Supreme Court decided that states can disqualify people running for state office. Now, there's nothing in Section 3 of the 14th Amendment that says this applies to the federal government differently than the state government. It says you're disqualified, period. But the Supreme Court articulated this different. So in New Mexico, a county commissioner was disqualified from running for office because he was at the Capitol on January 6th. He appealed this decision and said, well, Congress didn't say that. And the Supreme Court rejected his case and said, you're running for state office, New Mexico can keep you off the ballot. Now, this line at the bottom left, states have no power under the Constitution to enforce Section 3, especially the presidency. This is the holding of Trump v. Anderson from the United States Supreme Court. In a presidential election, the impact of the votes cast in each state is affected by the votes cast for the various candidates in other states. Now, we're here to review the US Supreme Court's 2023-2024 term. And I don't know whether we're allowed to comment on it, but I'm going to comment on this. This is just not right. There were, and maybe there'll be pushback, so I welcome that. There were lots, I think, several legal hooks for the US Supreme Court that they could have grasped onto to overturn the Colorado Supreme Court. But they grasped onto the wrong thing. It is absolutely not the case that we directly elect the President of the United States. Very simply, the 12th Amendment says, we run this thing called the Electoral College. You want Colorado's 10 Electoral College votes? You come to Colorado and win our election. You want Utah's 6 Electoral College votes? You go to Utah and win their election. They have a different process for getting on the ballot, different filing fee, different people show up to vote. You have to win that election. This is a map that shows you the population divided by the number of Electoral College votes. And you can see the states are not treated equally, the voters are not treated equally. In fact, because of the Electoral College, we know Colorado doesn't even matter. If Trump wasn't on the ballot here, doesn't matter. He would win or lose regardless. Now the Supreme Court's worried about a race to the bottom. There was a complaint filed in Illinois to remove Biden from the ballot for being an insurrectionist because he's aiding the enemy with his immigration policy of letting all these people over the border. So there's a concern that states are going to start engaging, again, as Aaron pointed out, against presidential candidates instead of worrying about presidential candidates. But the Electoral College specifically says that states run these elections. So to say that states don't get to have power, especially for the presidency, is a little rich. What about ballot access? Robert F. Kennedy's not on the ballot in every state. In fact, he's trying to get removed, but only in the states he thinks it's going to help Trump, but not in all the states. Jill Stein's on the ballot in some states. This is okay. This is how the process works. RFK, here's a story that says RFK is going to be forced to be on the ballot in North Carolina, even though they already printed their ballots and early voting started. We're going to postpone the election, reprint the ballots, miss the federal deadline for mailing ballots to people in the military, but at least he's going to get off the ballot, but not in Wisconsin. Sounds kind of chaotic. If we're worried about that, we should stop this. We're not. The only thing we're stopping is the ability of states to prevent insurrectionists from representing us, not all these other things. Here's something else that happened in the primary. Trump was on the caucus ballot in Nevada, but not the primary ballot. Nikki Haley was on the primary ballot, but not the caucus ballot. Joe Biden wasn't on the ballot in the New Hampshire primary. Donald Trump and JD Vance won't be on the voter pamphlet in Oregon because they didn't pay the fee and they didn't submit it. That's okay. That's how the Electoral College works. If we're going to have this thing, which is problematic in my opinion, but if we're going to have it, we should at least be able to use it. That's what I think. And so I welcome, again, pushback. What about the voters that exist in each state? Different states allow voters to register at different ages. In Colorado, you can register when you're 16. Some states require you to wait till you're 18. What about states that allow felons to vote? You want to win in Colorado? You've got to appeal to an electorate where ex-felons vote. You don't have to do that in Florida. So my main pushback against the Supreme Court's opinion is that they've identified this idea that states don't have the right to run their own presidential elections. When Article 2 of the Constitution says states get to decide how electors to the presidential system are decided, and the 12th Amendment says states get to do that. There were other elements of this, but this was the thing that got all 9 justices. They disagreed on some other things, but the holding itself was unanimous, and in my opinion, rooted in just a faulty argument.
So, so we're going to have questions, but before we do, we only have a few minutes, but I wanted to first ask if any of the panelists wanted to respond or add to or modify any of the other panelists' statements. Okay, all right. Yes, go ahead in the back.
Can I ask, just to finish with Professor Spencer, what about the issue of issuing claim preclusion? Would Colorado's decision have that effect nationwide? And was there concern a good one for that reason?
I suspect that there was concern among justices. Again, when I said the Colorado Supreme Court may have erred by staying its own opinion, it's because that was they were acknowledging this is a federal thing. This is weighty and it might have impacted other states. So we should probably seek a different body's opinion. So even our own state seemed to be worried about something like that, when I think the Supreme Court should have said, the Colorado Supreme Court, this is our state law. This goes for us. You do what you want. You know, there's nothing that in other areas, when we say to get on the ballot, you have to pay a $500 filing fee, that doesn't then require other states to adopt a uniform system. These rules are adopted state by state, and a determination like this, I can imagine, would be persuasive if somebody brings a claim in Illinois and says, hey, the Colorado court with a 5-day hearing found out that Trump did this, you should do the same, but there's nothing legally that would require another state to rely on our court's determination.
What about issuing claim preclusion? Hasn't it been decided that he engaged in an insurrection? It's been decided, right, at a hearing. So wouldn't it? I'm a little advocate, but isn't the Supreme Court correct to be worried that this could go everywhere, and that we would have other states saying the opposite? That it could be like a race to the courthouse or something like that.
Possibly, but when you require the president to be elected by the Electoral College, these are all of the things that happen, right? That's part of the thing that's a challenge here, is if we directly elected the president, then something that happens in Colorado does affect what happens in Florida. But when Colorado's votes are circumscribed here, and you can win by 100% of the vote or 2% of the vote, and you get our 10, and it doesn't impact what happens in another state, I hear you. And I also will say there are some conservative scholars, and you may have heard of them if you've been following this case, Michael Paul Stokes and Will Bode. And they have been excoriating the Supreme Court for not being originalists, because they're originalists. And their point is exactly this. Well, the court did say Donald Trump was disqualified, and the Supreme Court can't take that away. So their view is actually more extreme than yours, which is even with the use of the Supreme Court's case, Donald Trump isn't allowed to be president. That goes too far for my liking, but I definitely agree there are concerns about this. But for me, we've made this bed called the Electoral College. We have to sleep in it, and we can't pretend that of all of the things we now are precluding states from doing, it's preventing insurrectionists from running for office. But in every other way, we allow the states. In fact, even out of Colorado a few years ago, there was a case, can a state legislature force a member of the Electoral College, an elector, to vote a certain way? And the Supreme Court's like, of course, because states are in charge. So I just feel like it bothers me because it feels like we're not being attuned to reality, even though the reality is complicated and maybe messy, maybe not the right equilibrium in the end.
Other questions? I want to ask a question about the administrative law cases. Obviously, it's one of the headline outcomes of this court. And I just want to get both of your takes maybe on how impactful you think this is going to be, because I've heard differing opinions about whether the taking away of Chevron deference actually changes anything significant with regards to how courts are going about their business. And other people believe it to be significant, right? This is the biggest thing, and it will dramatically change outcomes with regards to administrative agency regulations.
You want to go first?
Sure, I'll take a stab at it. So the Supreme Court actually hadn't been citing Chevron for several years. And my understanding is that the Department of Justice also hadn't been citing it in their own briefs for defending government actions. And so by all accounts, Chevron was dead. And it wasn't being relied on. It was still being referred to in lower court decisions, thanks. Yep. And so there was perhaps some confusion over what effect Chevron should have had. So in some sense, this doesn't change much except to say that nobody should be citing to it. There was also a critique that some judges were deliberately avoiding Chevron anyway, to the extent that they wanted to reach the substantive aspects of a statutory provision. And so they were just being cute in how they were avoiding the Chevron ambiguity step. And so in that respect, this doesn't change much because now judges can just go straight to the text and not have to walk around the Chevron issue. So I think that's probably a fair reading of it.
Yeah, I think I agree with that legally. Culturally, it's a huge shift because it'll affect how agencies interact with the people they're regulating. Because you used to be able to come in and say, look, you'd complain like this, your regulation doesn't comply with the statute. They're like, tough luck, the discretion is ours. They're going to defer to us, and then you just get run over. And I think that is going to change conversations. I think it'll probably change drafting of regs, and I think it will change the quantity of regs that are challenged in what different ways. Exactly how much, that's going to be really hard to measure and track, but I think the interactions are going to feel different between regulated entities and agencies now.
Right. 1 minute question for Shannon. Can we really separate the regulation of the large media, social media platforms and the large traditional media, New York Times, Washington Post, et cetera, especially because they also run online content and people can respond on that online content?
Yes, I mean, obviously, we all want to try to take the questions that are raised in the social media context and say, and look for examples that we already know and understand, like newspapers. And, I think Justice Kagan was pretty clear, like there are aspects of that jurisprudence that remain the same. But there are just these really important differences too. There is the issue of scarcity, and there's only going to be so many newspapers and print out there, whereas the number of social media platforms that can exist is infinite. Also, the New York Times doesn't get 1 billion posts that it has to review to decide what it's going to publish every day, but Facebook does, and it has to moderate these things with different techniques. And so I don't think it's a perfect match, but I think, we've heard from the court, the principles that underlie our First Amendment jurisprudence with respect to traditional media still apply, and we need to defer to those, while simultaneously recognizing just the inherent differences that are posed by questions about social media platforms.
Great.
Did I punt well enough?
Just like the Colorado punter. Good job. So my main job, unfortunately, is to keep us on time, and we are right at that. I'm hoping the panelists might stick around for if people want to talk to them afterwards. For those here for CLE credit next week, you'll receive a link to this presentation and a survey to share your thoughts with us. In addition, Colorado attorneys are going to receive a link for the CLE affidavit. Hopefully you'll join us for future events as well. For those interested in more CLE credit, I'll just give a plug. The Byron White Center at the University of Colorado, October 24th, will be hosting Fifth Circuit, United States Court of Appeals, Fifth Circuit Judge Stephen Higginson, who will be talking about the Nuremberg trials. And so that is also for CLE credit for those interested. But barring that, let me say thank you to our panelists. Please join me in thanking them.